guys. Hello. I am so excited to go through this with you guys. I'm having some technical difficulties, but it's fine. It's fine. How's everyone doing today? How's everyone doing? If I sound different, it's because I broke my laptop. So my mic is a little bit different. I don't have my other one plugged in. And I'm not in the room I'm normally in because I'm renovating it. I'm redecorating it, whatever you want to call it. So a lot's going on, but I wanted to go over this with you guys in detail because I know I had a lot of questions about this lawsuit, and I saw a lot of people sort of get out there, get ahead of it, get their commentary out there, and that's great. But all of that commentary, for the most part, I should say not all, but most of it, has been based entirely on news reports of what happened or what went down between ScarJo and Disney. And those reports haven't been entirely accurate in their portrayal of what's actually in the lawsuit itself. And that's not uncommon for them to basically say, this is the lawsuit, this is why they're suing, these are the issues that are going before the court, and it not simply be the case, either because they're intentionally exaggerating or they just don't understand what the lawsuit is about. So I decided to go ahead and pull it myself so that we can go through it page by page and see exactly what she's alleging and what she claims Disney did. Now, here's the thing. Here's how it happens. The news reports are saying that she is suing Disney for breach of contract. Okay? That is not exactly what is in the lawsuit. So when we go through it, one of the things you'll notice, and we'll go over it, but one of the things you'll notice is that she's actually suing for tortious interference, which is basically saying that she had a contract with this other party, this other entity, a subsidiary of Disney, Marvel, and that Disney interfered with that contract and caused that contract to be breached. So it's not saying I had a contract with Disney and they breached it. It's not saying, I agreed to do A, B, and C, and they agreed to do D, E, F, and then they didn't do it. It's saying I had a contract with this other party to do this, and they didn't comply. But they didn't comply because of something Disney did. And that is a much more difficult lawsuit. That is one where you kind of have to wonder how they're going to be able to prove it. And the allegations, guys, are not very strong. It's not at all what I thought when I was reading these news articles that portrayed this as this huge, significant thing in the industry. It is significant in the sense that you don't see actors suing Disney every day, or even Disney itself being sued every day. But it's not as strong a lawsuit as I would have thought, and I'm not entirely surprised. But I am somewhat surprised by the whole thing. It's kind of crazy. But before we get to it, we're gonna go through the chat, see who's here, see what your early impressions are, what your first thoughts are about this, and then we'll start going through the lawsuit page by page and figuring out what is going on, what is she saying, and what is the court likely to do, and what is Disney going to be able to say in response, okay? So, Eastland Burkholder is here. Thank you so much. Welcome. She says, I'm interested in the specific language of what exactly was promised by Disney, and did they fail to do as promised? And again, that's exactly what the media has been putting out there. The Disney promised to do something and then failed to do it. But that's not what the lawsuit is alleging. What the lawsuit is alleging is that Disney interfered with the contract and caused, or at least contributed significantly to that contract being violated. So, did we see that coming? Did we expect that to happen? Eastland then says, legally, that's the issue. That's what we thought the issue was. That's what we thought it was. But we'll see. We will see. Dadman is here. Good afternoon. Hello. Oops. I also don't have my mouse working today, so we'll see how that works. Eastland asks, and I'm not an expert, but do the lead actors and actresses usually have control over how it's released? I thought no. It depends entirely on what's in the contract. So, what she's essentially saying is that she was promised an exclusive release in theaters. But as you'll see, it's a bit more complicated than that. So, it depends. You can contract for anything that's legal. So there may be actors and actresses who have zero control whatsoever, and you may have others who've contracted for some control, or at least some promise, some reasonable expectation that the other side has agreed to comply with. But it has to be in the contract, and that's where she's going to have a little bit of a problem, I think. So let's keep going. Theme Park Casual is here. Hello, hello. Dax Morgan is here. Hello. And no, I wasn't live yet. I don't have my longer counter, but we'll fix that. We'll fix that next time. Lord Anubis is here. Hello. Thank you. Thank you for joining us. I'm sporting a bit of a Cajun accent. Yeah, maybe. I don't know. We'll see. Oh my God, the chat jumped on me. Shane is here. Hello. Bone is here. John Pearson is here. Hello. Runner. Kaylee. Jay Allman is here. We have a full house today, guys. We have a full house. Tina Bojan is here. We got Archer Jacob Barton is here. Billy Duncan is here. Ancient One. Everybody. Hello everyone. Please do share, hit that like button, do all those things so that we can get a full house, even fuller, so that everybody can go from here with a better understanding of what's actually happening with this case, because there is a lot of misinformation and the media isn't helping. Media isn't helping at all. But let's go ahead. Let's get started. So let me stop sharing the Washington Post because they weren't helpful. They weren't helpful either. And so the case, let's start with some information just to sort of set the stage. This is a complaint filed in the Superior Court of California, County of Los Angeles. That's where the parties both operate out of, or at least have offices. And I'm going to show you exactly where I got that information from, if I can. Hopefully I'll be able to share it. So this is, if you search by the name of the case or the name of the parties, you'll get to the case access sheet on the court website. And it basically gives you the case number. So you have to search by the name, then you grab the case number, and then from there, you can actually access the case documents. And that's all I did. There is a cost associated with it. So if you guys want to get copies for yourselves so that you can have it to do your own analysis, that's all I did. I basically just went to the website and grabbed it. It wasn't working yesterday, but it is working today. Grab that information. It shows you exactly what you can order, meaning you can get a copy of the complaint, which is 18 pages. You can get a copy of the notice of case assignment. This is going to tell you who it's assigned to, who is the judge who's going to be overseeing the case. And that's actually kind of interesting too. We're going to take a look at the assignment sheet because the judge who's involved in this case actually has a history of working with a studio, and a very, very powerful one. So he is more than aware of this industry. He has experience with it directly, and that could play a part in his decisions in the case. You can also get a copy of the cover sheet, and you can get a copy of the summons. I pulled the complaint, the assignment sheet, and the summons because that tells you how long Disney has to actually respond. And that'll tell us how long we have to wait because they released like this kind of snarky, I don't know, press release, whatever it was. You know how they do. You know Disney. You know how Disney is. They released this snarky response, and everybody's like, "Oh, they slammed her. They got her good." But it's not an official response. Like you can say whatever you want to the media. You can say whatever you want to the press. You can leak whatever statement you want. You're not going to be held in contempt or anything if you're lying. But you're not perjuring yourself if you're lying to the news media. But you can't necessarily do that in a legal case. You can't do that in a pleading. So what really matters and what we'll be looking for is them to file a response, an answer, anything. It could be a motion for summary judgment, and we'll get into that later. It could be a motion to dismiss. There are all sorts of things they can do, but that's what we need to see. We need to see what they say officially in response to this case. And I think they're going to have a lot to say and pretty good grounds to stand on. But again, we'll get to that in just a minute. So yes, we close some of these tabs. That gives you a little bit of an overview of how I access these documents, where they are, and that you guys can get your own copy at will if you want to look through it yourself or do your own analysis on your show. Now, one more thing I do want to take a look at and show you guys, which I thought was interesting, I think it will shed some light on what's happening, is that Deadline actually did publish a copy of the complaint. They filed their own copy of the complaint. And what's interesting about Deadline's copy, what's interesting about it is that it doesn't have a case number. It doesn't have a case number. So what that means is that they leaked it. ScarJo's people leaked the complaint before it was filed. And given how weak their case seems to be, it does kind of suggest that this may be a publicity stunt or an attempt to put some additional pressure on Disney based on basically the media and society, playing this out in the court of public opinion, knowing full well they may not be successful if it were to go to trial. It seems like this may be, I don't want to be a conspiracy theorist, but when you leak your complaint, because what they could have done, they could have just filed it and then called Deadline and said, hey guys, call the courthouse. Check and see if anything's been filed today. And Deadline would have gotten a copy that way, and it would have the case number, and it'll look like, Deadline just did, investigative work. They were at the courthouse, they had their people there, and they saw it come in, and they were the first to present it. But instead, this document was leaked because the only people who have a legal document before the court is the person filing it, which is just ridiculous. So just understand if you're going for, like Dak said, you're pressing for a settlement and embarrassment, that's one way to do it. But it is interesting. It's very interesting that they leaked it in this way, in such an obvious manner. But yeah, I did want to point that out before we get started. I thought that was a bit hilarious. And I'm not at all shocked that they would do that. It's funny. Okay, so let's pull up, and I'm gonna try not to go too fast. I know I can talk fast when I get sort of excited about it. But let's see. Let me pull it up. Okay. Nope, that's not it. That's the summons. Hold on. What do you guys think of that? That was crazy to me. All right, here we go. This is it, guys. This is the petition. This is the complaint. And you can see it has a case number, right? So it's been filed, unlike the copy the deadline had. And as you can see, it tells you where it was filed here at the top. It tells you when it was filed and the clerk of court who received it. It gives you the docket number. Everything that's filed in the case will be filed under this docket number. So again, if you're tracking it at home, if you're watching the case, you're following it, that's the docket number you would use to access the documents as they're filed. These are the attorneys, well, the law firm for Periwinkle Entertainment, who is working on behalf of Scarlett Johansson. It is Casowitz Benson Torres LLP. These are the attorneys who work in the firm who will be handling the case and their contact information. Let's see. You have cases filed in Superior Court for the state of California, County of Los Angeles, and they're suing Walt Disney Company, Delaware Corporation. They are demanding a jury trial. But here's what's key. The complaint is for two legal actions. The first is intentional interference with contractual relations. Tortious interference. They're saying that Disney interfered with and caused the breach of contract. And again, here, the second one is inducing breach of contract. But for Disney's behavior, which she describes in the complaint, but for that, the contract would have been complied with and she would get what she feels that she lost as a result of Disney's action. So this is the title page. This is the caption of the lawsuit. It gives you a sense of exactly what they're suing for and why. All right, so Eastland asks, are you sure the Scarborough side leaked it? Could someone have left off the case number after getting it like you did? Not refuting, but what you say, asking if it's possible. So typically what happens is the attorney's office has the document with no case number on it, and you file it, and you get a docket number. So it's immediate. It's not, there's no delay between when you who possess the document file it, that the court then files it. So there's really no way anyone else would have had it unless they sent a copy to Disney first or at the simultaneously, which I don't know why they would necessarily do that. It's not typically what you do. Under that logic, Disney could have leaked it, but I don't really see why. Technically, her side was solely responsible for it before it was filed. Okay, so let's move to page 2. Now, page 2 gives us an introduction, basically an overview of what happened. This is entirely from ScarJo's point of view. It's their perspective on the case. It's their breakdown. So you can take it take it with a grain of salt if you like, whatever you want to do. But this is entirely her side. Nothing's been proven yet, okay? One normally needs a smoking gun memo to sue for and win for tortious interference. Agreed. But guess what? You wait. You wait until you see what is actually written here. Oops, I missed the super chat. Raj H with a $1.99 Canadian super sticker, a thumbs up. Thank you. Thank you so much. And Bone with a $1.99 super sticker. And I can't see what it is. It's not showing up for me for some reason. But thank you. Oh, it's a little puppy with the hearts. Thank you. Thank you so much. Yeah, I doubt the court would leak it either. It's not something, you don't really expect that. But let's get into the first section. So the first section is the introduction. This is entirely ScarJo's perspective. And this is not a specific allegation of facts. It's simply an outline and overview to give the court some perspective on who ScarJo is, what their agreement was, what each party did from their perspective, who's responsible, the consequences, what have you. And so we're going to go through it, and I'm going to read it. I'm going to actually read it for you so you can hear, in case you can't see it very well. Introduction. Over the past decade, Scarlett Johansson's work has generated billions of dollars from Marvel Studios and, by extension, its parent company, Disney. In recognition of and reliance on this impressive track record, Marvel and Miss Johansson agreed that her compensation for starring in the latest motion picture addition to the Marvel Cinematic Universe, the MCU, Black Widow, the picture, would be based largely on box office receipts generated by the picture. To maximize these receipts and thereby protect her financial interest, Miss Johansson extracted a promise from Marvel that the release of the picture would be a theatrical release. As Miss Johansson, Disney, Marvel, and most everyone else in Hollywood knows, a theatrical release is a release that is exclusive to movie theaters. Disney was well aware of this promise, but nonetheless directed Marvel to violate its pledge and instead release the picture on the Disney Plus streaming service the very same day it was released in movie theaters. Wow. So this very first paragraph tells us that we're going to be looking for language about this agreement concerning her compensation. Did it promise her an exclusive theatrical release? Did they simply promise to release it in theaters? And is there a difference there between those statements? She also claims Disney was well aware of the promise, but were they bound to it themselves? And she says that Disney directed Marvel to violate it. Can she prove that that's what happened? Is she going to tell us how Disney made Marvel, directed them specifically to violate this agreement that they had with her? Oh, it's going to get good, guys. It's going to get good now. What are your thoughts on this general overview so far? You know what? The John Beck, it's relevant. It's going to be very relevant that the streaming service was up and coming because the streaming service didn't even exist at the time of this contract. It's going to be very, very interesting. Ryan Kennel, hello. He says, can't stay, and I think there'll be lots of argument over the widespread theatrical release verbiage instead of exclusive theatrical release. Exactly. Thank you for stopping by. And yes, that's the crux of the argument. That's the crux of the case. And a lot of the language in this, one of the things you'll notice in the lawsuit is that there's a lot of language about promises and understandings and all that. But when it comes to a contract, your understanding is in the four corners of that contract or it doesn't exist. You can't read into it anything. You can't read into what people thought, what they had to have known. None of that stuff matters. The only things that matter are the verbiage, the words that are on that contract. And the words apparently from Disney that made Marvel violate it, if you can even say that Marvel violated it. So that's exactly what this is going to be about. And I don't know. I don't think she's going to be able to pull this off, y'all. I don't think she's going to be able to pull this off. And yes, Tina, they mentioned later on this alleged addendum, but it still doesn't say what I think it needs to for her to be successful. Shane says the model was theatrical then, early on. Exactly. It was so much of that context will play a role here. I wonder what Disney's response is going to be. But let's keep going. So, paragraph 2. The reasons for this were twofold. First, Disney wanted to lure the picture's audience away from movie theaters and towards its own streaming service, where it could keep the revenues for itself while simultaneously growing the Disney Plus subscriber base, a proven way to boost Disney's stock price. Second, Disney wanted to substantially devalue Ms. Johansson's agreement and thereby enrich itself. In the months leading up to this lawsuit, Ms. Johansson gave Disney and Marvel every opportunity to right their wrong and make good on Marvel's promise. Unlike numerous other movie studios, however, including Warner Brothers, who, on information and belief, settled with its talent on films such as Wonder Woman after it released those films day and date to its streaming service, HBO Max, last year, Disney and Marvel largely ignored Ms. Johansson, essentially forcing her to file this action. Ugh. And that was a question that I raised, was it yesterday? I don't even know, a day or so ago. Would Disney follow in Warner Brothers' footsteps and settle? Or would they do what they typically do, which is ignore people? And apparently they chose to ignore her. But it may be for good reason. It may be for dirty and low down, but it may be that they're legally on good grounds to do that. So we'll have to see, because Disney had every motivation in the world to move to everything to their streaming service. That's absolutely true. You have quotes from the CEOs saying exactly that is basically being their intention long term. We know this. And yes, it boosts their stock price. We've seen this story over and over again since they started their streaming service. But just because you have motive to do something doesn't mean that what you did was legally wrong. And when people file lawsuits like this and they, in a way, waste time talking about stuff that's not the contract in dispute, or when they, basically try to divert your attention elsewhere instead of the specific acts that are at issue that you say someone did, it makes me wonder. It's like, why are you watering down your complaint? Why are you watering down the petition, weighing it down with all this excess information? Tell us what the agreement was. Tell us what Disney did. Tell us how you know they did it. That's all you have to do. But that's not what they're doing. That's not what they're doing. It's almost like they're trying to gain sympathy and support from people who read this. But sympathy and support isn't going to win a lawsuit. It's also not going to cause Disney to necessarily do anything to help you. If she thinks this is pressuring them, I don't know that it is if they feel they have solid ground. Jay, hello. He says, how did you get this? Are you a spy? You missed the first part of it. You missed the first part of it. The website finally worked, so I was able to get a copy, just paying for it and downloading it. It's all public record. It's all public record. Accidental Tourist says, only Jane Theory can make a legal document sound pleasant. I know. I'm trying to make it entertaining. It would be boring, but for how much flowery language they put in. And that's another thing that's so unique about this. It doesn't have the legal language that you tend to see where it's kind of complicated and complex, jargon. It's not any of that. Like it's almost written like a story for a movie script or something, trying to make it entertaining. Maybe because it's directed more so to the general public than to the court, if that's what this is all about. Eastland says, so the legal document is a press release. Exactly what I was getting at. One more like for 30 like hype. Yes. All right, so let's keep going. Let's keep going. It's getting better, right? So paragraph 3. Now we get into who Miss Johansson is. They talk a little bit about what makes her so valuable. So Miss Johansson is one of Hollywood's most well-known and talented actresses with decades of acting experience and a lengthy filmography of critically acclaimed and financially successful performances. After making her feature film debut at just 10 years old, she has appeared in both comedies and dramas, including numerous award-winning films such as Lost in Translation, Vicky Cristina Barcelona, Marriage Story, and Jojo Rabbit. Paragraph 4. In 2010, Miss Johansson proved that she could also perform in an action-packed blockbuster when she appeared in Iron Man 2, a superhero film based upon characters and stories from Marvel Comics. In that film, Miss Johansson played Natasha Romanoff, better known by her superhero name, Black Widow. For her work, she garnered significant acclaim, including a Best Supporting Actress nomination from the Academy of Science Fiction, Fantasy, and Horror Films. She went on to reprise the role of Black Widow in 6 more films, helping to build what would eventually become the MCU, one of the biggest and most lucrative film franchises ever created. Oh my God. Oh my God, y'all. This is hilarious. This is hilarious. Oh my God. Okay, Ancient One, thank you for joining us. Guys, feel free to come and go. We're just on page 3. In 2019, Marvel Studios officially announced that Black Widow and Miss Johansson would have their own film. Prior to this announcement, representatives from Marvel and Miss Johansson had finalized a deal for her services in connection with the picture. Here we go. That deal is set forth in an agreement dated as of May 9, 2017, and a series of amendments thereto collectively referred to herein as the agreement. At issue in this lawsuit is the portion of this agreement that guaranteed her a share of box office receipts, meaning receipts from movie theater ticket sales. To protect her financial interest in these box office receipts, Miss Johansson obtained from Marvel a valuable contractual promise that the release of the picture would be a wide theatrical release. Was it though? Was that the promise? Was that in the contract? Did the contract say that? And even if it did it say it was exclusive? Huh? Let's finish this paragraph. Both parties, as well as Disney, understood this meant that the picture would initially be released exclusively in movie theaters, and that it would remain exclusively in movie theaters for a period of between approximately 90 and 120 days. This roughly 90 to 120 day theatrical window was not only industry standard at the time the agreement was finalized, but also standard practice for prior Marvel movies distributed by Disney, including those starring Miss Johansson. And here is where we run into the problem, guys. Here's where we run into you cannot have this level of vagueness in a contract. The court, the fact finder, is not going to read into the contract what you guys understood, what is industry practice. It's like she's arguing custom, but you have a contract. And a contract is going to trump custom. So you have to have these words in the contract. If they're not in there, They're not enforceable. This is potentially a problem. She's basically saying everybody understood it would be exclusive. That's what we had in mind. But did you put it in the contract? Is that what it says? Well, no. Oh. Maybe your lawyers didn't do such a great job. I wonder. Paragraph 6. And we're getting into page 4. In November 2019, approximately 6 months after the agreement was entered into, Disney launched Disney Plus, its wholly owned flagship subscription video on demand service. Leading up to this launch, the on-demand market was crowded with established players such as Netflix, Amazon, and Hulu, and newcomers such as HBO Now and Apple TV Plus, all competing for subscribers. We remember this. In order to convince consumers that Disney Plus was worth the $7, now $8 monthly access fee, and to convince investors that the service would be profitable, Disney announced that the offerings on Disney Plus would include Disney's entire library of films, a number of library television series, original content, and crucially, that Disney Plus would eventually be the go-to source to stream the MCU. Now, when they heard this, Miss Johansson and her people got nervous. They were shook because of this contract, right? Paragraph 7. In light of these announcements, Miss Johansson's representatives sought assurances. They sought assurances that Marvel would hold up its end of the bargain with respect to the theatrical release of the picture guaranteed in her contract. Now, what's interesting so far is that they haven't referenced or included provisions of the actual contract, nor that they attach the contract as an exhibit. Now, obviously, if this goes farther in the case, they're going to have to do that, and we will get to see the actual contract. But as of right now, they haven't. And again, that concerns me. It reads more like a press release than someone trying to enforce something or hold someone responsible for violating the enforcement of that agreement. It's just, if you have a solid contract, you lead with the contract. And that's not what they're doing here. It's suspicious. It's almost as if they know that this is a problem. Eastland says, it is standard practice. Does not help me if you do something different from standard practice. The court says, so what? And we'll look into what was promised by each party and not delivered. Exactly. Valiant says they probably can't attach the contract to the public filings due to the NDA. We would have to see. Not necessarily, but they could reference specific provisions of it. They could tell us what it said, especially since they're saying it was violated. But that's a good point. Maybe that's why they haven't attached the whole document. But they're not even, one of the things you'll notice is they're not even relying heavily on it either. Like, they're not, one of the things you continue to see is this reference to understanding and what other people thought and what they thought and what Marvel thought and what Disney had to have thought, and not, this is what the contract said, this is what Disney did. It's not, I don't know. It doesn't read like they're really relying on the contract to make their case. It reads like they're relying on emotion to persuade the public and perhaps the court to feel sorry for them and to enforce it. But I don't see it here. But here's what they said. They sought assurances from Marvel. Now, what you would think they would have sought instead of assurances was an amendment to the contract. But they sought assurances. How did they seek assurances? By what means? Did you call them? Did you email them? Did you get an addendum? What did you do? And by the way, what did you think whatever you did would have any impact on the contract? Because the contract is still the four corners of the contract. That's the only thing that's going to be enforced. So these assurances that they're saying they're getting, it's of no consequence if it's not in the contract. But what's crazy is that the assurances are a little bit vague as well. In response to their representatives seeking of an assurance that they would hold up to their end of the bargain, at least as ScarJo interpreted the contract, Marvel's chief counsel confirmed to Mr. Johansson's representatives in May of 2019 the following. This is what they said. We totally understand that Scarlett's willingness to do the film and her whole deal is based on the premise that the film would be widely theatrically released, like our other pictures. We understand that should the plan change, we would need to discuss this with you and come to an understanding, as the deal is based on a series of very large box office bonuses. And apparently they were okay with that. Like, apparently ScarJo's people were good with that. It's how do you, okay, let's say this was in an email. They just told you nothing. That was not a confirmation of anything. It was a reiteration of what you said. It wasn't a confirmation of anything. And it's almost like the language was specifically written that way to protect Marvel. We totally understand her willingness to do the film, her whole deal, was based on the premise, the idea, the notion that the film would be widely theatrically released, like our other pictures. That's fine. Okay, cool. Yeah, we know. She wants it dropped in theaters. Okay, cool. And we understand if we decide not to do that, we need to talk about it with her. If we decide not to throw it out there, maybe not to send it to theaters. If we decide to drop it exclusively on our streaming service, then we need to talk to her about it. We told her it would be released theatrically, and we understand it needs to be. And guess what? Guess what, guys? It was released theatrically. They just also released it on their streaming service. Are you beginning to see the problem here? Are you beginning to see the issue? Eastland says it's okay to say the contract specifically states and to say certain conditions and events were guaranteed and set down specifically even with an NDA. Yeah. And another thing too, if an NDA prohibited them from attaching it or what have you, they could still attach it under seal. Even if you're prohibited for some reason, whatever reason, from publishing a document, you can still file it with the court under seal and reference specific paragraphs. So if they had said per, page 8, paragraph 6, line 21, whatever, that would at least tell us that there is some specific language in this contract that they're talking about. There's a very specific, not just promises, but obligations here that she's trying to enforce, or she's saying that Disney interfered with. That would tell us quite a bit, right? That would lend credibility to all of this. But you don't even have that. You don't even have that. This is crazy, y'all. This is insane. But that means less money for her, right? Says Nina. Absolutely, it could have. And that's what we're going to get into as well later on when they start talking about Disney's motivation. It gets really complex because no one knows. Like, Disney could literally come to the table and say, look, infection rates are going up. We have new strains of this virus. It's going to be 2020 all over again. We need to drop everything we have that's good as soon as we can. If we're going to get this movie out at all timely, we need to do it now. They could very well make the argument, and I think believably, that things could get worse in the fall and the next spring, and therefore they wouldn't have had a chance to make anything on this. And you know they're going to get their financial experts at the table. That's the other thing missing from this. There's a lot of opinion in this complaint and no expert opinion. Like, they cite news stories and news articles. Like, y'all are going to be, you can't believe this. They cite everybody but an actual expert who has crunched the numbers and said, this is what Disney expected. I don't see it, y'all. I don't see it. Kayla said ScarJo may lose this one. She might. She might, y'all. Hey, Phil. Okay, so again, this is all, her side is trying desperately to frame this in their favor. So what they go on to say is that Marvel thereby confirmed the parties' understanding. This confirmation outside the contract, it has no bearing on anything. Nobody cares. Nobody cares. But they say that Marvel thereby confirmed the parties' understanding that, one, the box office bonus component of Ms. Johansson's agreement represented the lion's share of her expected compensation, which is a two-edged sword in this environment. And two, the wide theatrical release that Marvel had promised would be like our other pictures, meaning the standard Marvel MCU 90 to 120 days of theatrical exclusivity. Meaning, see, she's trying to insert meaning, additional definitions and understanding that aren't in the contract into it. And you can't do that. You can't do that. And even when they say that we're going to release it like our other pictures, that's still not a promise of exclusivity. Saying you're going to release it like your other pictures is just saying you're going to release it like you did your other pictures. You release this one to theaters, you release that one to theaters. And here's the other problem. If you released one to theaters and then 90 days later dropped it video on demand, and a different one you released to theaters and 120 days later you dropped it on demand, that's not consistent. That's basically saying that you are determining when you drop it on demand. You have sole control over that. Like with your other pictures, which means you're writing into this a lack of exclusivity. You're trying to argue both exclusivity and lack of exclusivity at the same time. And the court's not going to get into who understood what your understanding of the language was, what their understanding of the language was, doesn't matter. What does your contract say? It sounds like all it says is that they're going to release it in theaters. That's what it sounds like. And she would have a stronger case if the like our other pictures language, if that's in the contract. And I'm not sure it is. I'm not sure it is because she's referencing this response in support of that argument instead of the contract itself. This could be a serious problem. This could be a serious problem for her. All right, paragraph 8. Now we get into 2021. In late March 2021, however, in direct violation of these promises and her agreement, Disney announced that the picture would be simultaneously released in theaters and on Disney Plus Premier Access, a service available only to Disney Plus subscribers that provides unlimited on-demand access to select films for an additional $30 per film fee beyond the monthly subscription cost. On information and belief, which means you don't have anything concrete. This was the direct result of Disney directing Marvel to ignore Ms. Johansson's agreement and or overruling Marvel's wish to comply with it. In the marketing campaign that followed, Disney frequently highlighted the picture's upcoming availability on Disney Plus, usually side by side with Ms. Johansson's image. Throughout this process, Ms. Johansson, through her representatives, attempted to negotiate with Marvel to reach the aforementioned alternative understanding that Marvel's chief counsel had promised under these circumstances. Ultimately, however, Marvel ignored this outrage. No resolution was reached, and the picture was simultaneously released in theaters and on Disney Plus Premier Access on July 9th, 2021. Oh my God. This looks like a long article. It reads like one. It doesn't read like a legal document. Nations is not a legal argument. There are no legal arguments. They did. And it's perfectly like, of course she reached out to resolve it. Of course she did. But Disney said, we don't know what you're talking about, man. Disney dropped their response and basically said, be what? How dare you? This is not, it is nuts. This is nuts. And that's just paragraph 8. Now we're on page 5. Paragraph 9. And this is where they get a little bit snippy. They get a little snippy. To no one's surprise, Disney's breach of the agreement successfully pulled millions of fans away from the theaters and towards its Disney Plus streaming service. According to Disney's own self-congratulatory press releases, the picture grossed more than $60 million on Disney Plus Premier Access in its first weekend alone. Okay. Disney didn't breach the agreement, though. You're saying that they directed Marvel to breach the agreement, right? You're gonna have to pick an argument. You're gonna have to pick one. Did Disney breach it or did Marvel? I don't know why they didn't sue them both. That's the other question I have here already. But here's what they get into. Here's where they get into what other people thought. So now we're talking about what Marvel thought, what ScarJo thought, what Disney might have thought, and now it's what these other publications thought, what the press thought. Paragraph 10. As numerous publications noted, this strategy dramatically decreased box office revenue for the picture. According to an article from one well-known Hollywood trade journal published 3 days after the picture was released, veteran distribution executives say it's clear that the availability of the movie on Disney Plus cannibalized box office, noting that an entire household might have gone to see the movie in the theater but could instead pay just $30 to watch it together at home. Another article from a different but equally well-known and established industry publication declared, there's no question the Disney Plus premiere availability of Black Widow ate into its domestic opening weekend box office. Notably, however, Disney's stock price jumped 4% in the days following the picture's release. Here's the problem I have with this paragraph. One, you're not citing your sources. Are we talking about Variety magazine? Are we talking about Deadline? Who are we talking about? Because what you consider a Hollywood trade journal is questionable, as you guys will see later. A Hollywood trade journal. They make it sound like it's an expert. It's not an expert. It's not an expert. When they say Hollywood trade journal, they're literally talking about these websites that produce Hollywood news and entertainment reports. That's literally all they're talking about. They're not talking about actual trade journals. And I didn't pull every single one they referenced here because it's just annoying after a while, but I did pull 2 of them. One was Variety magazine, and another was the Chicago Tribune. The Chicago Tribune is not a Hollywood trade journal, and yet they refer to it as that. Like, this is Spirian with a $5 super sticker. Thank you. It's a how's it going pair. Thank you. Too cute. It's gossip. It's gossip. It's not even here. It's more like speculation because these people don't know. They don't know anything. They don't know any more than anyone. These people are literally like us. It's like they're like better paid YouTubers. They're giving their opinion on entertainment news. And yet her attorneys are referencing these news articles as if they're influential in some way, as if they have any bearing whatsoever on anything. Hollywood trade journals, the trade journal language is the type of language you might use if you're in a medical malpractice case and you're saying that a doctor failed to do some specific thing. You can pull a trade journal that has very detailed medical information and medical opinions and perspectives from people who know, from people who did the exact same thing the doctor did, but did it better, maybe, or people who that doctor would have relied upon in his decision making or his education or his training. This is not a trade journal. This is not a comparable situation. These are news articles from people who just made an opinion that they felt would get them clicks. Like, are you serious? Why is this in a lawsuit? Or if you're going to include it in the lawsuit, you should include it's like they don't know how to cite things, which I thought you learned at least in college, but certainly in high school. You should cite the author so that we know if this person knows what they're talking about. You need to cite the publication so that we can find out if there's any bias. And you need to tell us the page, the website, so that we can look at so that we, the court, the fact finder, the jurors, whomever, can look at the document, can read it for ourselves and see what it says in context. Because what you'll see is that some of the things that they report aren't even in context. I'm telling you, it's insane. It's crazy. All right, let's move on to paragraph 11. Of course, this was Disney's plan all along. This was Disney's plan all along. Disney knew that a day and date release on Disney Plus would drive up the total number of Disney Plus subscribers, a key metric impacting Disney's stock price, both by luring new subscribers to Disney Plus and by giving existing ones reasons to keep paying their monthly fees, thus reducing subscriber churn. Disney also knew that having such a well-known film as the picture debut on Disney Plus would help it justify future price increases to the Disney Plus monthly subscription fees. Moreover, Disney knew that its ability to deliver blockbuster content like Black Widow to its subscribers would perpetuate the view of many investors, as reflected in Disney's share price, that Disney Plus is the only streaming platform that has a chance to one day compete with a rival streaming giant Netflix, providing another way to bolster Disney's market valuation. In short, Disney chose to placate Wall Street investors and pad its bottom line rather than allow its subsidiary Marvel to comply with the agreement. There's motive. There's motive. You may even say there's opportunity, but is there a crime here? Is there a crime here? It's great. You're piling on the dirt on Disney. I love it. I love it. You're making them look horrible, but you're not necessarily making your case. Let's see. Tommy says if they use an article, it needs to have figures and sources. Exactly. ScarJo's attorneys are dropping the ball. I think it's either that I don't think they're that incompetent. I think what this is that it's not a serious lawsuit. I think it's more they are trying to put pressure on Disney to settle out of court. That's what this sounds like. Definitely damages. I mean, they have to prove that Disney did what they said. They have to prove even before that Marvel was obligated to them for an exclusive release, an exclusive theatrical release. If she can't prove, if it's not in her contract that theatrical release was supposed to be exclusive. Whatever her damages, Marvel's not responsible. And if Marvel's not responsible, then neither is Disney. A fishing expedition, oh yeah, it's about to get good. It's about, because what they're going to do now they filed this case, they're going to have depositions. They're going to call all these people to question them. But then at the same time, that's going to drive up legal fees too. And yeah, you can say, well, she has the money. She can do that. It's like she can at least annoy Disney, even if she doesn't win. But at some point, if she does lose, she's going to be responsible for not only her attorney's fees, but theirs. Emma Stone is seeking to sue as well. I heard that. And I wonder if her case is any stronger. She may need to chill out a little bit and see what happens, but she may be throwing that out there. Now, here's the thing. If all these actors decide to all sue at the same time, I mean, that could stretch Disney's resources thin. That could put some pressure on them. If they're not just fighting one actor, but all of them, not to mention producers and directors and others who were realistically hurt by the simultaneously streaming. I mean, they could explain why Warner Brothers settled so quickly. And maybe it could put pressure on Disney to settle as well. Emily Blunt is suing over Jungle Cruise. That would be crazy. A class action is a possibility. Absolutely. But again, I don't know that they have a strong legal case, but they could put enough pressure on Disney to force them to come to the table, which is something Disney hates. They hate that. They hate negotiating. All right. Paragraph 12. Page 6. We're getting closer. The icing on the cake for Disney was that with the bulk of Mr. Johansson's compensation being tied to box office receipts, Disney knew that the cannibalization of such receipts by Disney Plus would save Marvel, and by extension, Disney, very large amounts of money that it would otherwise owe Mr. Johansson. On information and belief, Disney intentionally induced Marvel's breach of the agreement without justification. COVID might be a justification. In order to prevent Mr. Johansson from realizing the full benefit of her bargain with Marvel, Disney's financial disclosures make clear that the very Disney executives who orchestrated this strategy will personally benefit from their and Disney's misconduct. In fiscal year 2021, Disney's chief executive officer, Robert Chapek, was awarded equity grants totaling 3.8 times his $2.5 million base salary. The primary justification for the award, according to Disney's compensation committee, as detailed in the company's 2021 annual report, was that Mr. Chapek worked to quickly program new offerings on our direct-to-consumer and linear channels and launched our direct-to-consumer services in several key markets. Robert Iger, Mr. Chapek's predecessor, also received the overwhelming majority of his compensation, just over $16.5 million, in the form of stock grants. The reason for this mammoth award, according to the same annual report, was that he successfully launched Disney Plus and drove unprecedented subscriber growth in the first year. In short, the message to and from Disney's top management was clear. Increase Disney Plus subscribers, never mind your contractual promises, and you will be rewarded. Ooh. Guys, that's still a lot of, they had a motive. They had a motive. But it's not, motive isn't enough. What did they do? Dax Morgan said, even without a strong case, a class action would be an enormous stroke to make Disney settle handsomely to avoid the PR disaster for all their prime actors suing them. And it could, potentially hold them hostage if these people decided, we're not working with you again. Now, I don't know if they would be willing to do that, but it would be interesting. Tommy says maybe Lucas will bring a slavery case against him. I can't stand Disney, but it all seems like posturing. It does. It does. Let's keep going. All right, so that takes care of the introduction. The next couple of sections are pretty procedural. They talk about jurisdiction and venue, which basically says that this is the right court for this case. This is the right court for the case. It affirms for the court who the parties are. These are the correct parties. And one of the things that came up, I know, was who is Periwinkle Entertainment? These are what you call a loan-out company. So when famous people are like, have your people call my people, these are those people. These are the people who basically act as intermediaries between the talent and the company, kind of a little bit more than an agent. And there are all sorts of tax reasons why you would organize like this if you're an actor or a singer or something. But that's all. It's basically just her people who are responsible for her work and who are the ones who would be paid directly, who are suing on her behalf. And so then you get into the factual background. And before you get into it, each one just tells you a little bit about what that section is going to be about. I will skip around a little bit here just because they repeat themselves. They repeat themselves a lot in this complaint. And it's like, why? If you had something, you wouldn't have to do all that. But here's what they do. They take up a lot of space by talking about Miss Johansson and her casting as the role of Natasha Romanoff, Black Widow. They talk about her being an esteemed and versatile actress with over 25 years of Hollywood acting experiences. They get into her credits, all the movies and awards, a 5-time Golden Globe nominee, BAFTA awards, all that stuff. She's great. They basically want to say she's great, she's valuable, she's worth it. She's worth all this money. She's worth all this money. She's so significant to the MCU and Marvel and blah, blah, blah. So they talk about all that. She's so great. She's great. She's wonderful. And here they throw in there that Miss Johansson accordingly prepared for the role with months of strength training, as well as extensive training in stunts, hand-to-hand combat, and weapons combat. She worked her butt off for this role, and she was great in it. And she won so many awards, all this and that. So that's what they have to say about that. She's golden. Pay her due. Exactly. She deserves to be paid. She deserves to be paid. So then you get into the agreement. Before we go to that, though, let's see what the chat has to say. Nina says, I wonder how this is going to affect movies going forward, like the cast of Shang-Chi, whatever that movie is, and Eternals. Yeah, it's going to be interesting to see what promises they thought were made. And I say thought because a lot of this has to do with understanding. So I don't know what the understanding was for them. Eastland says, or it would be a PR disaster. Scarlett is getting older and Disney might not care. Disney might not care. And yes, exactly. Alan Foster and the other writers, they do have legitimate cases because they had contracts where Disney bought those contracts or assumed those contracts. And with that came a responsibility to pay them. Those are direct breach of contract cases. That's what I initially thought we had here. But that ain't what we got here. That ain't what we got here. And who's to blame? So then they get into the agreement, and we're on page 8. Paragraph 21. The agreement, dated May 9th, 2017, sets forth the understanding between Periwinkle Entertainment, the lender, and Marvel, referred to herein as producer, concerning Ms. Johansson's, referred to as artist, services in connection with the picture. Paragraph 2, titled Engagement, states, this is what it says: lender shall furnish producer the services of artists to perform the role of Black Widow, Natasha Romanoff, in the theatrical motion picture currently entitled Black Widow Picture. For the avoidance of doubt, if producer in its sole discretion determines to release the picture, then such release shall be a wide theatrical release of the picture, no less than 1,500 screens. Guys, was there not a wide theatrical release? Was there not a wide... Did people not go to the theaters to watch it? Do you see the word exclusive anywhere? Do you see the word exclusive anywhere, or even a time frame? No. You don't. Dom TV 2010 says, get your popcorn ready. Yeah. I feel like there was some additional language that should have been included there. They're going to get her on that? That's crazy. Yeah. You can already begin to see what Disney's going to say in response to this. You can already see it. You can see what she said was promised, and you can see what they actually promised and what they actually did. That Trini Gamer, hello, with the $2 super chat, says, this just looks like a lot of BS written on paper. It does. Thank you for the $2 super chat. And you're absolutely right. I think you're right. Eastland says, Disney bragged about big ticket sales. Seems a wide release. Yeah. There was a wide release. They can say, yeah, we said that your release would be a wide release, and it was. It was. We never said we wouldn't also release it other ways. And you might, okay, so they may argue, well, we didn't know at the time that there would be a Disney Plus. So how can we foresee what you would do with it? The problem is that there was video on demand. There was all sorts of ways to release movies, either exclusively in theaters or at the same time you release them other ways. That was possible. Maybe not, through the streaming service, but it was possible to do other ways. And they didn't protect themselves sufficiently at all. Eastland says, you might have wanted mayonnaise on your burger, but you did not have a contract for mayonnaise on your burger, and you got a burger. Right? We said we were going to give you a burger, and that's what you got. If you wanted it your way, you had to put your way in detail in your contract. And see, here's how you know that they know that they're in trouble. In paragraph 22, the very next paragraph, they say, at the time the agreement was entered, it was well understood. It was well understood by the parties and Disney that a theatrical release referred to an exclusive release in theaters for an extended period of time that was roughly 90 to 120 days. Everybody knew. I thought it. Surely they thought it as well. When we signed this thing, we both had it in mind, right? But we didn't put it on the paper. We thought it. We were on the same page, intellectually, mentally, emotionally. We didn't reduce that understanding to print. Right? They didn't say they didn't want onions on a burger. Eastland, I think when you talk about shares of reruns, those are completely separate contracts. So I'm not sure that it creates precedent, especially if she loses. She would have to win to create some sort of precedent. And then I'm not even sure what it would be. I'm not sure what it would be here. I mean, just imagine, is the judge or the jury going to say, well, you didn't put it in the contract, but you understood that to be the case? That would be a dangerous precedent to set for contract, period. I mean, that would be incredibly problematic for contract law, for people to start imputing into it all sorts of things. Now, I mean, there are exceptions here and there for when you can do it, but when you're talking about key terms, specific actions that parties are supposed to take in reliance on a contract, you can't start reading into that other action that's not in the contract. That would be devastating. I mean, it would make it not a contract anymore. Like, you wouldn't be able to rely on them anymore. This could be, that's why I don't think she's going to win. I don't think she's going to be successful. And then they go on to say, with the exception of certain less valuable direct-to-video releases, it has long been custom and practice in the film industry for feature films to have at least a 90-day exclusive theatrical release before they're released on home video. And so if we know there are exceptions, and it's not mentioned in the contract, then exclusivity was not inherent. See, she could maybe squeak through a custom and practice argument if it was exclusively that custom and practice. But she's noting here exceptions. You're telling us there are exceptions. So what is the court supposed to do? The court can't filter through whether you have in mind an exception or whether they do. That's why the four corners of the contract rule is enforced. That's why that's important. That's why the court doesn't let you just throw stuff in and after the fact based on what was in your head. You can't even say that that's exclusively the custom and practice in the field, in the industry, if you're admitting that there are exceptions. And then not only do you admit there are exceptions, you also admit there are exceptions to the 90-day rule. So even when the 90-day rule is, or some sort of rule pertaining to that is going to apply, you acknowledge that although some films have started to see shorter theatrical windows. So what are you telling us, ma'am? Like, what are you? Oh, okay, so let's finish this one out. Marvel Studios' previous films have generally had theatrical windows consistent with the industry standard, and sometimes even longer. Specifically, Marvel Studios' previous feature films had uninterrupted theatrical windows between 82 and 159 days, with an average uninterrupted window of 117 days. Of the 7 Marvel Studios films in which Miss Johansson starred prior to the picture, for which Miss Johansson also received certain bonuses tied to box office receipts, none had a theatrical window shorter than 96 days, and none included day and date releases on streaming platforms, as would come to pass with Black Widow, Rather, in connection with those films, it took 6 to 8 months before Marvel Studios' film would be available for streaming on a video on demand service like Disney Plus. Custom and practice. It's a custom and practice argument. Tommy says, well, honestly, it's understood in law that a handshake agreement is binding. Far as I know, that's never been removed. I still think this is her and Disney just throwing tantrums at one another. Let's be clear here. A handshake agreement, a verbal agreement, is binding when you don't have a written contract. When you have a written contract, there is no agreement outside the contract. When you have a written contract, there is no agreement outside of that. That's why you have addendums and amendments and all this stuff that happens over time. But if we have a written contract and then we have some random conversation in Walmart, and I'm like, yeah, sure, I'll do X, Y, and Z, and you're like, oh, yeah, cool. Well, you have a written contract. The court's going to enforce the written contract, not what we joked about at Target. It's not how it works. It's not how it works. And her attorneys had to have, like, how did they not know? How do you prove a handshake? Well, it's the same. It's a verbal contract. There are ways of proving a verbal contract. It's a different standard. There are ways. There are ways. We won't get too into it because that's not what we have here. What we have here is a written contract. Even though they're trying to get in there, the other conversations that took place outside the contract and what people understood outside the contract. But the only thing the court's going to care about is what's in the contract. Archer Jacob Barton, bye. Have fun. Thank you for joining us. The Time Prophet says, perhaps if Joe bangs her head on the table, it'll solve the problem. Oh my God. Oh my God. I mean, she needs to do something at this point because this is not helping her. Paragraph 23. We're on page 9 now. Halfway done. In further recognition of the importance of a traditional and exclusive theatrical release, what does it matter how important it is? Okay, let me read it. The agreement also grants Mr. Johansson the right to full and meaningful consultation in good faith with Marvel as to the initial release pattern of the picture. Okay. What does that mean? These promises concerning the picture's release, including the language requiring a wide theatrical release, it did not require the language, set forth on the very first page of the agreement and in the same paragraph that establishes Ms. Johansson's role and services, were material and essential to the agreement. That's a bad sentence. Wait a minute, let me reread that. These promises concerning the picture's release, including the language requiring a wide theatrical release, set forth on the very first page of the agreement and in the same paragraph that establishes Ms. Johansson's role and services, were material and essential to the agreement. That is because, in addition to certain fixed compensation, Ms. Johansson was to receive the deferred compensation and bonuses directly tied to the amount of worldwide box office receipts for the picture. The greater the box office receipts, the more Ms. Johansson stands to earn. In other words, Ms. Johansson's compensation for the picture hinges upon box office receipts, and by extension, a traditional exclusive theatrical release consistent with Marvel's past theatrical releases. That would allow her to realize the full value of her bargain. Would it though? I mean, in addition to what they're saying, relying heavily on understandings outside the agreement. Can they say that she would have realized the full value of her bargain if they had just dropped it straight to theaters in the middle of a pandemic? I mean, how are they going to prove it? How are they going to prove it? You have to, like, why do we not see numbers here? Nina says she needs to get the court of public opinion on her side. Yeah, that's how cases are won these days, but Disney may not care. You know how Disney is. They will ignore you. So all right, the next section talks about it sort of gets back into Disney's motivation. And what the CEOs had to say, basically. So on August 8, 2017, Disney announced its plans to launch a new Disney-branded direct-to-consumer service in 2019. This then unnamed service would eventually become Disney Plus, a video-on-demand platform that is wholly owned by Disney and features films and television series from an array of Disney brands. By the time Disney Plus launched on November 12, 2019, it was competing with a number of other major subscription streaming platforms, including but not limited to Netflix, Hulu, Amazon Prime Video, so on and so forth. So they talked about this before. Blah, blah, blah. They get into, again, Ms. Johansson's representative reaching out to Marvel once Disney announced that they would be releasing their own films and series on the streaming service. And their concern was that this decision might impact the contract. We'll go over this again, even though it's a repeat, because they do add at least an additional paragraph. In light of these announcements, Ms. Johansson's representatives reached out to Marvel to confirm that the launch of Disney Plus would not impact the exclusive theatrical release that Ms. Johansson had bargained for. She had not bargained for that in the agreement, but whatever. David Galuzzi, Marvel's chief counsel, responded on March 20th, 2019. And this is what he had to say. So they're adding a little bit more of what the conversation. Further to our conversation today, which it sounds like that conversation was verbal. We just talked about that. It's 100% our plan to do a typical wide release of Black Widow. We have very high expectations for the film and are very excited to try to do for Black Widow what we've just done with Captain Marvel. Okay. We totally understand that Scarlett's willingness to do the film and her whole deal is based on the premise that the film would be widely theatrically released, like our other pictures. We understand that should the plan change, we would need to discuss this with you and come to an understanding. The deal is based on a series of very large box office bonuses. So what this additional paragraph tells us is that they did have a conversation, presumably over the phone, but the only thing they confirmed is their plan to do a typical wide release. They did not reiterate or affirm Johansson's understanding that it would be an exclusive wide release. It would be a typical wide release, but it wasn't good. They didn't say exclusive. They made sure not to say exclusive. And her attorney didn't catch it. Because they could have followed up with, okay, so per our email, per your last email, per my last email. So we do understand this is going to be an exclusive wide release, right? Like we're both talking about exclusivity here, right? Right? They could have followed up with that. They could have had an emergency meeting to address that. to get that in the contract. They didn't. They didn't, though. And Mr. Galuzzi attached a fully executed copy of the agreement to the email. So it was an email. But here's how they shape what the lawyer said. Thus, Mr. Galuzzi, on Marvel's behalf, communicated his understanding that Ms. Johansson's box office bonus was her primary consideration under the agreement, that the picture would be widely theatrically released, as it was, and that this release would be like our other pictures, which it was, meaning exclusively to theaters. No. Meaning, no. You can't interpret what he said. You weren't in his head. You should have confirmed that in the next email. You should have emailed him back. You didn't do that. Not that it would have helped. I mean, but you can't. No, you're trying to now say what he meant, and he didn't say that. He didn't say that. You can't tell us what he meant. In fact, he's going to get on the stand and testify that that is not what he meant. How dare you? He didn't mean that. Who told you that? What do you mean? I never meant that. I meant what I said what I said, right? I said what I said. Section D, page 11. Well, we're still on page 10, but it goes into page 11. In blatant breach of Marvel's promises to Ms. Johansson, Disney gives the picture a day and date release on Disney+. The picture was initially scheduled to be released on May 1st of 2020. However, its release was delayed several times during the COVID-19 pandemic. As of September 2020, the picture was scheduled to be released exclusively in theaters on May 7, 2021. By early 2021, industry commentators began speculating about the possibility that the picture's release might be delayed again, or, in the alternative, that it might be released simultaneously in theaters and on Disney Plus for a premium price. When asked by an industry publication in January 2021 if the picture would stick to a theatrical release or go to Disney Plus, Marvel's president, Kevin Feige, was non-committal. Non-committal. So you have all these reports coming out today about how upset Feige is, and oh my gosh, I can't believe it. It's so wrong how she's been treated, blah, blah, blah. He was non-committal when it mattered. He was non-committal when it mattered. Why does he have an opinion now? Why now is he so upset? According to this, he admitted that parent company Disney, not Marvel, was calling the shots when it came to Marvel Studios content on Disney Plus and in the theaters, and that the intent was for the MCU's storytelling to continue to unfold both in theaters and on Disney's flagship streaming platform, stating, "All I can tell you is that for the past 3 years since Bob Iger brought me into this office and talked about a streaming platform that would become Disney Plus and asked us to start working on programs for it, our long lead plan was to have the MCU and the storytelling woven between weekly episodic big swings on Disney Plus and into the feature big swings in theaters." Oh my God. Oh my God. How does this help you? How does this help you at all? It doesn't tell you that Disney directed anything. It doesn't tell you. Your contract is with Marvel. You have not given us proof of Disney directing Marvel to do anything or Marvel resisting. You haven't really even established that Marvel couldn't do what they did and not be liable for any losses you suffered. But putting that aside for a moment, Where is Disney responsible? Do you see it? Because I don't. I don't see it. Speaking about the picture on a February the 11th, 2021 earnings call, Mr. Iger's successor, Bob Chapek, stated that we are still intending it to be a theatrical release, but declined to clarify if it would be released on May 7th as scheduled or delayed again. In a February 12th article, Variety reported that Marvel's Mr. Feige was opposed to a hybrid rollout, but that the powers that be from Disney could still convince Feige to change his mind or overrule him completely. Now let's be clear here. They're citing Variety, not Feige. Seriously. I have it here. So this was a Deadline article. Was that it? Hold on. No, wait. That's not the one. Oh, let me find it. Oh, I hope I did. Okay, anyway. Dang it. I didn't pull that one. So there was a Variety article that they're referring to. Let me make sure I don't have it. Okay, I don't have it. I didn't pull it. What's important is that Variety reported that Feige was opposed to the rollout. However, Feige wasn't the one who said he could be convinced to change his mind. That's what Variety said. The way it's written here, it makes it seem like Feige was admitting or acknowledging that he's the one who could be convinced to change his mind by Disney. That's not what it said. It actually said that Feige could be convinced to change his mind in the opinion of Variety magazine or whoever wrote that article. So this is not exactly evidence that Disney did anything or that Disney could do anything. It's simply a news report's or news author's, a journalist's perspective on what could happen, their understanding of what could happen, their prediction of what might happen. But it has nothing to do with Feige, Marvel, or Disney. It's kind of sneaky that they would word it this way, because it does make it seem like Feige was the one who was saying that he could be convinced by Disney. That's not, he didn't say any such thing. And I wish I could pull that article. I don't know what happened. I thought I pulled it. Then we get to paragraph 34. March 17, 2021, Disney's Mr. Chapek cleared up any remaining doubt that it was Disney, not Marvel, calling the shots, telling Bloomberg Television that we'll make the call, probably at the last minute, in terms of how these films come to market, whether it's Black Widow or any other title. We'll be watching the call carefully and make the call when we have to. The problem with, again, it's how things are being worded. He said, we'll make the call. He could have been talking about Disney exclusively making the call. He could have been talking about we, Disney and Marvel together, will make the call. It's all about interpretation. It's all about Johansson's people reading into the minds of third parties, in this case, Disney execs, reading into the minds of the people at Marvel who signed off on this, reading into the contract what was in the minds of the people at the time it was signed. It's all about understanding and all this. That all of this is outside the contract. It's like, what are you talking about? Nina says, just sent you a Twitter DM. Gerard Butler now considering suing New Image, Millennium Media, and Padre Nuestro Productions. Oh my goodness. Oh my goodness. Maybe the actors are rising up. I don't know if they'll be successful, but they're rising up. As previously stated, Disney Plus Premier Access is available only to consumers who pay for a Disney Plus subscription. Those customers can then pay an additional $30 fee to unlock access to a new release that they would otherwise only see in theaters. Unlike traditional premium video on demand releases, which typically give the viewer a 48-hour window to watch the content they have purchased, once a Disney Plus Premier Access film is unlocked, the consumer can watch it as many times as she wants for no additional fee as long as she remains a subscriber. On May 24th, 2021, Disney's Mr. Chapek openly admitted that the theatrical market was still fairly weak from the pandemic and predicted that the marketplace will recover more fully and that type of exclusive theatrical distribution will make more sense. By the time other Disney movies such as Free Guy and Shang-Chi are released in August and September. Listen, here's the thing though. That was in May. Things have changed since then. Since then, you have Disney now requiring masks again. You have different public entities in different states starting to sort of buckle back down in their restrictions. All hell's broken loose since then. Like, how can you hold them to a prediction of what a theatrical release would look like in the fall when all hell's breaking loose in the spring and early summer? They didn't know. They had no idea. These aren't scientists. Like, how is he supposed to know? And that's probably what he would say on the stand. Like, yeah, I thought things would be better in the fall. But then we saw the numbers rise. And we figured we had to do something, And that could explain why they're so offended in their public response. Then in paragraph E, on page 12, they caption it, Marvel's breach is a direct result of Disney's tortious interference. And again, they get into motivation. Like, why would Disney forgo hundreds of millions of dollars in box office receipts by releasing the picture in theaters at a time when it knew the theatrical market was weak, rather than waiting a few more months for the market to recover? Maybe because they didn't know it would. How could they know? How could they know? See, you're really on thin ice now. You're on really thin ice now. On information and belief, the decision was made, at least in part, because Disney saw the opportunity to promote its flagship subscription streaming service using the picture and Ms. Johansson, thereby attracting new paying monthly subscribers, retaining existing ones, and establishing Disney Plus as a must-have service in an increasingly competitive marketplace. Ms. Johansson and the express promises that Marvel had made to her concerning the box office bonuses and a traditional theatrical release, like our other pictures, were simply collateral damage. By interfering with the agreement, and they haven't yet said how, and inducing Marvel to breach it, they haven't yet said how, Disney not only increased the value of Disney Plus, but it also intentionally saved Marvel and thereby itself, what Marvel's itself referred to as a very large box office bonuses that Marvel otherwise would have been obligated to pay Ms. Johansson. You have to do better than that. Now, maybe they intend to like I said, conduct some depositions, question some people, subpoena some documents, find some emails or whatever. But I don't see that they had the right to expect an exclusive release. We keep going back to what's actually written in the contract. And it's just not there. Here we go again. Disney unquestionably understood how it would benefit from inducing a breach of the agreement. When he announced the release of another Disney film, Mulan, on Disney Plus Premier Access, Mr. Chapek noted that under a Premier Access offering, not only does it get us revenue from our original transaction of premium video on demand, but it's a fairly large stimulus to sign up for Disney. Page 13. Moreover, Disney knew still more motive, but not action. Disney knew that the availability of the picture on Disney Plus would dissuade a number of would-be moviegoers, including many would-be repeat moviegoers, from paying to see the picture in theaters. How can you show that Disney's decision to release it on a streaming service was more of what dissuaded people than increased restrictions and warnings by the CDC and some state governors about going to public spaces and indoor spaces, having to wear masks? Like, there are so many reasons, so many other things that would dissuade people from going to the movies. How can you blame that exclusively on it being available simultaneously at home? Like, and then even if you can do that, what percentage? Like, what's more responsible? Because this is what Disney's going to say. Who's more responsible? Are we responsible for people not going to the theaters because we offered this on our streaming service? Or is fear of a deadly virus to blame for people not going to theaters? Like, you can see, regardless of whether you agree, you could easily see them making that argument and it making sense. They go on to say, when Disney first announced its plan to release the picture on Premier Access, no less than the New York Times described it as a move that will likely hurt cinemas, lower ticket and concession sales, while helping Disney higher streaming revenue. Similarly, one Hollywood trade journal opined on January the 11th, 2021, that it's insurmountably more challenging for a film the size and scale of Black Widow to become profitable without a traditional theatrical window. Well, yeah, like duh, but she was never going to have that. I mean, all the theaters aren't even open yet. On June 10th, 2021, 1 month before the release of the picture, another prominent Hollywood trade journal reported that with respect to Disney's day and date strategy, the whole game now is to bring subscribers into Disney Plus ecosystem and keep them there, and that this has been damaging for talent who are compensated by sharing in the box office receipts from a film, just as these news outlets predicted and Miss Johansson feared. The picture's box office receipts for its opening weekend were significantly below the opening weekend performance of Marvel's previous films and have suffered a steeper than normal decline since then. In short, Disney's strategy to lure viewers away from the theaters and towards Disney Plus worked. How can you say that? How can you say that? And this is an example of the whole trade journal thing, which I did actually clip. I thought I clipped the other one, but I definitely clipped this one. This was the Chicago Tribune. The insurmountable odds language that came from the Chicago Tribune. The Chicago Tribune is not a trade journal. It's not it's just a newspaper. It's just a newspaper, and it's their opinion. And because you're not telling us who the author is, who the audience is, what is their qualification, where are they getting this information, how are we supposed to know the credibility of it? Doesn't make any sense. So these trade journals, these newspapers, these news journalists, these people don't know. How could they have predicted that? This would make much more sense if you had industry professionals, people who study this sort of thing, people who crunch the numbers, and you attach to this complaint their report saying, yeah, this strategy was intentional. This is the effect it had. This is the percentage that COVID is responsible for in terms of losses. But this is the percentage that the studio is responsible for in terms of losses. That's something that could have been explained by someone with actual knowledge. Instead, they're relying on news reports and Scarlett Johansson's personal fears, and neither of which are relevant to this contract, its enforcement, or Disney's alleged interference. They go on to say, there can be no doubt that Disney's conduct was knowing and intentional. Indeed, as recently as March 1st, 2021, Mr. Chapek publicly acknowledged that shortening or eliminating the standard exclusive theatrical window could cut the legs off a theatrical exposition run. Yet, he and Disney have done just that, notwithstanding and in disregard of Marvel's contractual promises. But what did Disney specifically do? What did they do? What did Marvel tell you that they did? That's the information that I'm guessing at this point they're going to have to try and get through the discovery process because it's not here and they apparently don't know how. They apparently don't know what Disney did, but they're suing anyway. And again, they go on to say that this negative impact on traditional box office receipts is exacerbated by Disney Plus Premier Access model, which will allow viewers who pay the Premier Access fee to rewatch the picture an unlimited number of times, so long as they remain subscribed to Disney Plus. And then they go into how traditionally, if a moviegoer enjoyed a film, they have to go and see it a second time. Of course, you don't need to do that, right? So they attack the model of Disney Plus and how they handle Premier Access films. Again, nothing to do with the contract, though. So let's skip that part. Yes, with Premier Access, there are no repeat ticket sales. All right, paragraph 44. Adding insult to injury. Ms. Johansson has spent the last several months fulfilling her own obligation under the agreement to promote the picture and therefore, by association, its release on Disney Plus. In other words, Disney has enjoyed the benefits of having one of Hollywood's top actresses promote its wholly owned subscription service at no additional cost to Disney, and with the intended effect of taking money out of the actress's own pocket. Don't you feel bad? Don't you feel bad? Tina Bojan says, fact, the Chicago Tribune, then the Chicago Examiner, was the premier film industry trade journal from 1916 to 1924. Oh my God. Well, maybe that's the time we're living in. Maybe that's why everything's so crazy. On information and belief, Marvel's decision to release the picture simultaneously in theaters and on Disney Plus Premier Access, if it can be called Marvel's decision at all, was the direct result of Disney's tortious interference with the agreement. Absent this interference, it was Marvel's intent and desire to release the picture exclusively in theaters at a time that would have maximized box office receipts and therefore Marvel's and Ms. Johansson's profits from the picture. The only reason Marvel did not wait for a more opportune time to release the picture exclusively in theaters as intended is because it was induced or forced. It was forced by Disney to release it day and date on Disney Plus Premier Access to drive profits to Disney at Johansson's expense. How? You're going to have to prove that. I'm sorry. Nina says, in other words, Mr. Johansson sold out for not the amount she was expecting. Exactly. Oh my God. So we get into the first cause of action, which is the intentional interference with the contractual relations. And this is the part where I say it just reiterates everything that was said before. The high point here is that Disney intentionally and improperly induced Marvel to breach its agreement with plaintiff by releasing the film on Disney Plus simultaneously with its release in theaters in violation of the agreement, which required a theatrical release of the picture. As the parties understood that term at the time of contracting, meaning an exclusive theatrical release of the picture. No, we've already been through that. I'm sorry. And then the second cause of action is inducing breach of contract. Marvel breached the agreement, including its implied covenants of good faith and fair dealing, by releasing the film on Disney Plus simultaneously with its release in theaters in violation of the agreement, the same one they keep trying to say existed. Disney intended to influence, direct, induce, or cause Marvel to commit the above described breach because Disney knew it would benefit from such breach. Through its conduct, Disney caused Marvel to breach the agreement. Again, they don't say how. They don't say what they did. It's something they'll have to figure out, I guess. And then at the end, it has a prayer for relief. And so basically, at the end, they're telling the court what they're looking for. They're looking for monetary damages, meaning her actual losses. I don't know how she's going to be able to prove that. I mean, there are just too many questions about what a purely theatrical release would even look like in today's environment. What it would look like in the fall, the extent to which anyone knew or can possibly predict that. And then they're asking for punitive damages, which is basically saying, make them pay me in punishment for what they did, They're looking for interest. So they're not only do they want the money they say they're owed, but they also want interest on that. They want interest on the money. And of course, they want their attorney's fees and court costs paid for. So that's it. That's the whole case. That is the basis for this suit. That's the basis for the suit. What they contracted for, what she contracted for with Marvel, was the theatrical release of her film. What she got was a theatrical release of her film. What she thought at the time was that theatrical release would be exclusive, acknowledging that there are exceptions, but that was a reasonable belief on her part because of industry custom. Disney's going to say, not only was that not our understanding, but we ain't say all that. Marvel didn't say all that. And it's not in the contract. And regardless of what we agreed to, regardless of what we talked about by email and phone, regardless of what we said, when we were both at Walmart and Target, it's not in the contract, dear. You should have had better lawyers. So it's not exactly what we thought. It's not exactly what the media is putting out there. It's a bit more complex. Nina, right? Disney be like, be please. Guys. This is gonna be a tough one. This is gonna be a tough one. I kind of feel bad for her because it looks like they saw it coming. It looks like they saw it coming in 2019, and they knew there was a problem with their contract. Because you wouldn't have to try so hard to reaffirm the contract's terms and conditions if you didn't suspect that maybe those terms and conditions as you understood them were not reflected in the contract. Getting their people on the phone and then following up with an email is like are you sure? Are you sure it's going to be exclusive? Because the contract doesn't say exclusivity. It's going to be exclusive, right? They never agreed to that. So yeah. Now let's also take a look real quick before we close it out. It's been like 2 hours. My gosh. I wanted to take a look too at the judge. So I think this is the assignment sheet. Let me see. Yeah. Judge Draper, Robert S. Draper, is the judge assigned to the case. And what's interesting about Judge Draper is that when you go to look him up and see who this guy is, one of the things you'll notice is that in his background, well, let's start here. He was appointed to the bench in 2012 by former Governor Jerry Brown, and he's a registered Democrat. He received his degrees from the University of California, Berkeley. He became an associate at a law firm, O'Melveny and Myers, in 1968, and eventually became a partner. He represented people like Lockheed Martin and Paramount Studios. He represented Paramount Studios before going into private practice and eventually making his way onto the bench. So this is not someone who is, on the one hand, he's someone who knows the industry and how it works. On the other hand, he is a liberal. He sounds like a liberal. So maybe, who knows? Maybe he wants Disney to pay. Tina Bojan, you are absolutely right. If she loses this, either the lawsuit itself or this power play, who's going to want to hire her going forward? I mean, that, and I don't know. She's getting older. Maybe she doesn't care anymore. Maybe she doesn't care either. Maybe she feels she doesn't have anything to lose. And that's kind of the perfect person to go against Disney, someone who doesn't have anything to lose. It's a bold move. It's a bold move. This is a bold move. Killing off Adam and He-Man was not a bold move, but this is indeed a bold move. Disney's versions of Dune's Mentats. The Gerard Butler thing, I will definitely check it out. So that's Judge Draper. And last but not least, on this case, we need to look at one last thing, and that is the summons. Okay. Now, why is this important? Why is the summons important? It's important because it tells us what's coming next and the deadlines at play here. When you get served with a petition or a complaint, what have you, you have to respond in a certain time frame, or you can lose by default. Right? Like if you don't respond, then the court can assume that everything in the complaint is correct and just rule in the favor of the person who filed it. So here the summons tells the defendant, Walt Disney, that they have 30 days to respond and says the court may decide against you without your being heard unless you respond within 30 days. So we should be getting something from Disney within 30 days. Well, they responded by media, but no, that doesn't count. They need to respond in writing. They need to file something. And they haven't as of today, at least not since we started all this. So they need to file something in the court where we can actually see what their defense is going to be. Now, it could be that they just file a general denial. So that's basically where it says, we deny this, we deny that, we deny this paragraph, that paragraph, blah, blah, blah. We deny it all. She's full of it. They could say that. They could just do a general denial, but they can't lie. They wouldn't be able to perjure themselves. So it's going to be interesting how far they're willing to go in their response. And we will find out soon because they only have 30 days to do it. Or the case could get resolved by then. Who knows? Another thing they can do is ask for an extension within that time frame. We could see them file a motion for summary judgment, basically saying that the petitioners haven't made a case, and the court should just go ahead and rule now because they haven't made a case. Or they could file a motion to dismiss because they haven't made a case. So it's going to be interesting. This is when you grab your popcorn. You grab your popcorn, get your favorite snacks. In fact, do that. For the next couple weeks, stock up on your favorite drink, your favorite snacks. And when Disney drops their response, we'll gather back here. We'll gather back here and go over it. And see exactly what they have to say. But that's it, people. It's a lot less dramatic than we thought it was going to be. Let's see, what is Gerard Butler doing? Okay, so he's suing the production companies behind Olympus Has Fallen for unseen profits from the film. That's kind of different. Yeah, that's a basic compensation suit. But that's it, guys. Thank you for joining me today as we go through this insanity. I hope that this sheds some light on what's going on. I hope you guys feel a bit more informed about it. It's crazy. It's a lot. If anything, the lesson to be learned from this is if you decide to enter into a contract with someone or a business entity, make sure it says everything you anticipate it saying. Like whatever your understanding is, make sure it's in there. Because usually, if you're going to have a detailed contract, you'll actually have an appendix or something where you have like definitions. This means this. This means that. So that there's no confusion and there's no misunderstanding. Like we all understand what these words mean. But if you don't do that, then you can find yourself in a situation where maybe you did get screwed over, but it's kind of your own fault because you didn't read the actual print, not even the fine print. You didn't read it. You just sort of thought we had an understanding. We had an understanding. I thought we had an understanding. And no, you didn't. It's not in there. So yeah, if she wanted an exclusive theatrical release, I think her contract should have said exclusive theatrical release. And it didn't. And between then and now, it was never amended. It was never changed. It was never updated. So there you go. There's the lesson. There's the lesson. Hope everybody have fun. I know it can be boring, but hey, I'm going to leave this one up for a little while. I typically take the live streams down, but I'll leave it up a little while. And I will probably create an actual video going through it as well later. But I just wanted to go ahead and get ahead of it just in case Disney did drop something, but they haven't. So there's that. Thanks for joining me. Everybody have a great day. It's Friday. Enjoy all the games going on today. Friday Night Tights and Mario Kart streams and Among Us streams and all that. Have fun. See you next time.